వంద వెయిట్ చేసినామా Hi everyone, am I audible? Thank you, Santosh. Alright, so hello everyone, very warm good afternoon on behalf of whole LeDroit India team. My name is Ria Chhabra and I'll be your speaker for this webinar. And so before starting, let me brief you out about LeDroit and about me. So we started LeDroit in 2020 with the purpose of providing practical legal education to lawyers and law students. We all have been in law colleges and have seen and faced the problem that we are not aware of the legal practical world. And once we are out of the college, we don't know what to do. In fact, even after passing the college, we are unaware of what's the accurate career which we want to pursue with, whether it's litigation, whether it's corporate, and if it's corporate, which career we want to go for, because corporate in itself is a very vast field. So we, with that motive, we started LeDroit to provide you the accurate skills you need to create your career, to guide you on which career path is most suitable for you and the skills you need for the same. My name is Ria Chabra. I'm founder of LeDroit India, and I have got around 4.5 years of experience of working in corporate. I have worked with companies such as iCertis and Infosys. So, with that experience, I'll be sharing my experience of force major clauses with you all. What's the importance of it in contracts, and why do we need to focus on various areas while drafting a contract? Okay, so with that, I would like you all to give a brief introduction about yourself. Simply, I'll be asking like how many of you are from uh, currently in law school. So I'll be taking out like your current batch name and all. So you just have to raise your hands. Okay, all right. So how many of you are from first year? Just raise your hand. First year students. Okay, I can see only Niyati is from first year. How many of you are from second year? Okay, all right. How many of you are from third year? Great. Fourth year? Do we have people from final year? All right. Okay. So, do we have any working professional over here who has worked with or currently litigating or anything? Ravi, are you working? Okay. All right. So we only have two people who have work experience. Great. Good to have you all. So before starting with the session, let me just know like whether my screen is visible or not. Coming on to that, how many of you have watched the movie Oh My God, which was by Akshay Kumar? I believe majority of you have watched that movie. So what was the scenario in that movie? Can anyone brief me out about what anyone who would like to take the lead and say just brief out about the movie? What was the actual scenario, the case in that movie? Shraddha, would you like to answer? Anyone can unmute and answer. Okay, all right. So, as far as I remember, in that movie, that person had filed the case saying that it was an act of God, and because of that, he was not getting any claim from the insurance company. To because of which he filed a case in the court saying that the act of God is not justified. So he filed a case against the God. Now, what do we refer to the term act of God over here? What do you understand by that term? Give me your basic understanding of the term act of God. What do you understand by that? Natural causes. Okay, not by human. Come on, give me rapid answers. We are here for 1 hour. I think so. It will be getting extended for another 10 to 15 minutes. I'll not take much of your time. So just cooperate me with me on this and answer fast. Anything for which God is responsible. Yeah, correct. All right. So you all have got a clear understanding of what act of God is. Now, why do we mention this thing, and how do we mention the act of God word in contracts? Do we mention saying that it is act of God? Do you think so? That we are going to label it as that? No, we don't do that. And why do you think that we have to insert clauses which talk about act of God? Yes, that's the force major clause. Force major clause in very basic language, it means that these are the clauses inserted in contract so that you don't have, you cannot be held liable to perform the contract in case of any natural calamity or any other calamity. Okay, so in basic understanding, that's the meaning of your force major clause. Now, in more better understanding for you, it will be that unavoidable and unforeseen circumstances. Of course, when there's an earthquake, you are and you have entered into a contract with any of the party, you are not going to approach them and say, earthquake aya jo aya, give me my perform the contract, I don't care about it. You cannot do that, right? You have to cope up with the situation, you have to wait. Considering those type of situations, we insert a clause known as force major clause, and that we'll be discussing in detail. So with that, let me know if my screen is visible. One second. All right. So, force major, navigating unforeseen future events. We have understood and got the basic understanding of what the word force major means and why we insert it in the contracts. Now, there's a difference between, there are two types of terms that are used in contracts. Sometimes you may come across this term, that is vis major. It is similar to your force major, but there's a difference. In some contracts you will find this word, and in some you may find the words force major, or in some contracts you cannot even find the word force major or vis major, any of that. We'll be understanding all of these aspects one by one. So what do you understand by the word vis major? Vis major is your Latin term, which means, the word vis means force or power, major means greater or superior. Together they mean superior force or power. In short, your word act of God. So, vis major are the clauses inserted in contracts for the purpose of protecting people from act of God, such as natural calamities, earthquake, tsunami, cyclones, all those things. So, in that scenario, you will not be able to perform your contractual duties. You will be not able to provide services or do anything which you have agreed on in the contracts. Correct? So, to protect parties from the same and to not make them liable, and to provide a proper guidelines that how they have to proceed with the contract in case any calamity happens, what will happen to the contract in case they both end up in these type of situations where the actions are beyond their control. They don't know what to do with the same. So for that reason, we insert these type of clauses. Now, vis major means in Latin it means act of God. It is defined as an overwhelming, unpreventable event caused exclusively by forces of nature, such as an earthquake, flood, or tornado. So you have got a clear understanding that what do we mean by the term vis major? Basically, act of God, or events that are beyond human control, which are not controllable by you, and you cannot even predict them, like when they are going to happen, what will be the ultimate situation when they are going to happen. It may happen that you have done performed your duties in the contract, and when it's about the payment obligation that the other party has to pay you, at that time your act of God appears. So you may end up not receiving the payment. So how and what will be the scenario in that situation? Because you have already performed your duties and you were yet to receive the payment, but an earthquake happened, and now there's a situation that you don't know what to do with the contract, whether, because you will not go and approach the person, mera paisa do, correct? Jo mar gaye jo hua, give me my money because I performed for the contract. You're not going to do that. So those guidelines are given in your force major clauses, but over here we are talking about your vis major clause. Now with that, we'll be discussing about a major case law, that is the divisional controller, KSRTC versus Mahadeva Shetty 2003. This is a very interesting case. Before proceeding with this, I would like to know that do you have any query so far? Anyone? Just raise your hand if you have any query. Okay. So with that, I'll take that you don't have any query in the case. So what happened in this case was, with KSRTC, we are referring to Karnataka State Road Corporation. Okay. Over here, the claimant was a mason by profession, means mystery. The bus, he was traveling in a bus over here, and that bus faced an accident. It fell into a pit, rolled down, and caused an accident, due to which many people lost their lives, and some of them also got injured badly, like they got disabled. Out of which one was this, the complainant was one of the member who got disabled. And in order to get his damages or get a compensation, he filed a case against the Karnataka State Road Corporation. All right. The complainant was also hospitalized for a period of 7 weeks. He got various fractures. He got consequent damage to nerve system of the whole body below the hips, and the body has been functionless. Means the lower part of his body was not functioning at all. Due to which, and at the time of accident, he was also earning rupees 3,000. Now his body is totally damaged. He's not able to work, or he's not able to do daily, daily, to do things. He's not able to function normally. He's not a normal human being anymore. So in that scenario, he filed a case against the KSRTC, Karnataka State Road Corporation, claiming around 9.5 lakhs for them as compensation. So over here, do you think there was any act of God because of the accident? To add on to the situation, I'll say at that time it was raining when the accident happened.
Ma'am, may I please answer?
Yeah, sure.
Ma'am, it needs to be deciphered from the circumstances whether it was negligence, because minor raining or raining of normal level is normal, and it's not a precondition in which the party gets a chance to do an accident. So we need to consider that whether raining was normal or really heavy, and whether it was negligence or really an act of God. So, ma'am, according to me, if it was minor raining, normal drizzling, or casual raining, the petitioner should get compensation. But if it was really an unforeseen and unpredictable sort of raining, in which accident could really happen, then he should not get the compensation, because it would then be considered act of God.
Correct, Madhur. Anyone else would like to add on to it? Okay, so as Mother rightly said, that it totally depends on the circumstances and the scenario. So let's consider that at that time it was raining heavily and he fell into the pit. But the major defense they took, the KSRTC took, was that it was an act of God because it was raining, and due to which the driver couldn't see the road, and the bus fell into the pit and caused the accident. So they should not be held liable to pay up for the damages. This case was being handled under the Motor Vehicles Act, and this was the claim mentioned over there. To which the your court provided distinction between act of God and the usage of the same. The court said that the expression act of God signifies the operation of natural forces free from human intervention, such as lightning, storm, etc. It may include such unexpected occurrences of nature as severe gale, snowstorms, hurricanes, cyclones, tidal waves, and the like. But very unexpected wind and storm does not operate as an excuse from liability if there is a reasonable possibility of anticipating their happening. So if we don't provide these type of things, if we don't restrict the meaning of the act of God, there are high chances that people are going to use it in their favor and take a disadvantage out of it. Correct? So any law which has been provided to you, any right that has been provided to you, comes with a duty. you have to abide by the same. So there's a certain limitation on your act of God as well. You have to, if you are saying that you were not able to perform your contractual obligations due to act of god, you have to provide a proper backup that what was the situation at that time, how the act of god affected your performance or prohibited you from performing your contractual duty. So an act of god provides no excuse unless it is so unexpected that no reasonable human foresight could be presumed to anticipate the occurrence, having regard to the conditions of the time and place known to be prevailing at. So, whenever the judges have to decide on these matters, whether they are supposed to allow for the compensation, grant compensation or not, they look into the circumstances of the case, that what was the situation, whether the situation was controllable, whether the situation was uncontrollable, like it was totally because of like natural calamity and it was not able to control at all. So as Madhur said, that if the rain was dripping, then we are not going to consider it as an act of god, but if it was very heavy rain, then we can consider that it was an act of god. So based on that scenario over here, even though they made a defense saying that it was an act of god, but it was drizzling that time, so it will not be considered as an act of god but a negligence. Because of that, court passed order for compensation and the ksrtc had to pay the compensation. Clear so far? So you got the difference between that, how the act of god has to be used. You cannot totally rely on the same for the usage. Clear? All right, now we'll be moving on to the next. We already covered this one, the what was the major distinction between how we are going to use the term act of god. The expression act of god signifies the operation of natural forces, and but every unexpected wind and storm does not operate as an excuse from liability if there is a reasonable possibility of anticipating their happening. So why do you think flights get cancelled? The reason being, they predict the weather report, they check the weather, they look into the atmosphere, what's the weather condition right now, and then they go for the same, right? If the weather is not suitable, they directly cancel the flight because they don't want to take the risk of risking humans life. So if everything was very much evident at that time that a storm is going to come up, and still if someone flies that plane off, they will be considered as negligent. That situation will not be falling under the act of god clause, because they were very much able to predetermine the situation, pre-check the weather conditions, and still they took that decision and risked people's life. So in that situation, they cannot claim that they should not be held liable for the damages, but they will be held liable for the damages. Okay, so these are the basic things. But your force major clause, this vis major, mainly plays a role in defense when any case happens, when any party approaches the court for the breach of contract or for the purpose of claiming damages, this major clauses plays a role. So these are very important clauses on which you need to focus on what you are writing about. It's not merely copy pasting a clause. You have to consider the future the future problem scenarios which may occur. Okay, now moving on to next. Now we understood about the vis major. Now you might be thinking, what's the difference between vis major and force major? Force major is your broader term of vis major. Over here, force major is also a Latin term. It means, force major means an event or effect that can be neither anticipated nor controlled and includes both act of nature, example floods and hurricanes, and act of people, example riots, strikes and wars. So force major is your elaborated definition of vis major. It includes both act of people an act of nature, because we have developed, we are no longer living in an environment surrounded by nature, we are living in an environment surrounded by people. So there can be situations where you are not able to perform your contractual obligations because of a human act which you cannot control, when such as riots, or consider like whatever is happening in Bangladesh right now, it is beyond your control, you cannot control it, correct? You could not have anticipated it priorly while entering into the contract. Any person sitting in India and any person in Bangladesh, if they had entered into a contract, let's say in 2015, they couldn't have anticipated that this situation in around 2024 is going to happen. Correct? So these type of situations are considered under your force major clause, where we covered your act of nature, which is which vis nature, which we already covered, that is act of God beyond human control, and act of people, which is also beyond human control but is happening because of the people. Got the definition of the force major clear over here? Just gives a thumbs up. That's all I want from your end. Just give a thumbs up so that I know that you are listening. Thank you. Yes, Prerna, do you have any doubt? Okay. Now we'll be understanding the meaning with another case law, that is Dharan Jamal Gobind Ram versus Shamji Kalidas and Company. This is of 1961. So this is also another interesting case. Over here we are talking about the partition. The India Pakistan partition, which we could not have anticipated back in that time. So let's consider that two parties, in what happened in this case law was, um, two parties had entered into a contract for the purpose of goods sale. Okay, and that was majorly cotton. One second. Yeah. So your Dharan Jamal Gobind Ram entered into a contract with Shamji for the purpose of exchange of goods, delivery of the goods, that is cotton. And at that time, India was undivided. So Karachi was part of India at that time. However, due to partition of India in 1947, Karachi became part of Pakistan, making the performance of the contract as per the original terms difficult and complicated due to the change in political boundaries and the subsequent imposition of restriction on trade. So when the partition happened, of course, at that particular situation, it was not possible for people to trade or move anywhere here and there, because if they did, there was a strict, like there was risk of their lives at that time. Correct? So because of that, it was not possible for the parties to deliver the goods in Karachi. Now the case was filed in the court saying that for requesting for breach of contract. So the other party was requesting for damages, that the person failed to deliver the goods on time. So now they are claiming for damages. Over here, the main judgment passed by the Supreme Court was that the doctrine of frustration was applied to the case. The court found that the partition of India and the resulting change in political boundaries were unforeseen event that fundamentally altered the nature of the contractual obligation. So whatever the terms and conditions which were there in the contract when the parties entered into were totally different, but they could not have anticipated that India is going to be divided at that time, because of which the both the places will become two different countries, and it will be very much difficult to deliver goods, and it will be very much difficult along with expensive and impossible to deliver the goods on time at that time. So this clause, the contract was not made considering these situations. But since the force major clause was there, and this matter appeared in the court held that doctrine of frustration was applied, and the parties will not be held liable to pay for any compensation or damages. Reason being that this act was beyond their control, they could not have anticipated this in future as well. So parties were not liable to pay for any compensation or damages. Clear so far? Okay. Now we have understood the major difference between your vis major and force major clause. Now we'll be doing some exercises. If you have any doubt, let me know. We discussed two case laws over here. One was with regard to the partition, and other was with regard to the natural calamity, whether it is there or not. And you had to decide that what are the things which we have to consider while considering act of God. Okay, moving on to next. Now let's do some exercises to know that whether you have understood the concept or not. Read out the first one. I'll read it out for you. Take your time and answer in the chat box. Do you think that act of God will be applicable? The laborer was responsible, or he did a breach of contract? Okay, so a laborer at a mill left his job early during a cholera epidemic due to concerns of contracting the disease, and therefore failed to complete his work contract in an action by the mill owners seeking compensation for work done by the laborer. It was argued that the work contract had been breached. So we all are aware of breach of contract. What correct? So based on that, just tell me, do you think that the laborer had breached the contract over here, or whether it was an force major clause? Take a minute and answer. So do you think breach of contract is there? Yes, no. Just answer yes, no. Breach of contract is there or no?
No.
Please mention in the chat box. I'm looking at the chat box right now. Okay, so all of you are saying no. Yes, there's a breach of contract. Apurva is saying. Others? All right. So Apurva, why do you think that there's a breach of contract? Apurva, you can unmute and answer. Okay. All right. So over here, majority of you have answered that no, there's no breach of contract. Why? The reason being, can anyone else answer this for me? Like, why do you think that there's no breach of contract? What's the ultimate reason you can think of?
Because he contracted with disease while he was working in the contracted work, and it is unforeseen incident happened at the time of his work.
Okay. Okay. All right. Anyone else? All right. Apurva, you are saying that epidemic is foreseen and precautions can be taken prior. We'll come on to it later on. Okay. So, as rightly said by Venkata, yes, you're correct that there's no breach of contract. Okay, reason being that over here there was an epidemic due to which the person thought that he do not want to risk his life. And in situations like epidemic, we have all been in a situation recently, that's pandemic, COVID-19. Correct. In that scenario, we were not able to work properly. Many people stopped going to office, and offices also eventually did not allow people to come to the office until and unless it was very much necessary. So reason, because of that reason, and person thought that if he continue working in the office, his life will be at risk, and he therefore stopped going to the factory where he was working in. But over here, the mill owners seek compensation, saying that there was a breach of contract. No, there was not breach of contract because of the force majeure clause that eventually prevented the party from performing its duty. Yes, Niyati, go ahead.
Ma'am, what if factory owners have taken some pre-measures like so that the disease could not spread among the employees?
Okay, so every decision has to be taken considering the circumstances of the case. If the factory owner has taken all the preventive measures so that the disease is not properly, influenza is not shared with the people, in that scenario we can consider that there was a breach of contract, because proper instructions and proper steps were being taken at that time. But since this was an unforeseen event, and even in your COVID-19, that was an unforeseen event at that time. But after a certain time, people started calling people in office, like come to office and work. And when you visit the office, you will find that all necessary precautions were taken into consider. You were required to be vaccinated, you were required to wear a mask, you were properly sanitized, and other things. Your company was providing you with all the necessary stuff to make sure that you are protected. So much that some of the offices even replace their taps, because while touching the tap, you while cleaning your hands, you open and close the that tap, you have to, they even changed it and made it automatic one, so that there's no human touch or interaction, the influenza doesn't spread. So all those necessary precautions, if they are being taken into consider, and then if a person says that I'm not going to come to office, that will be considered as a breach of contract. Okay, now coming to the next, that schools were shut owing to the influenza outbreak. Uh, Outbreak. The school bus drivers claimed for their wages compensation under their transportation contracts during the period that the schools were shut owing to the influenza outbreak. So, what do you think? Whether there was a breach of contract, or whether the schools were required to pay for the compensation or not? Like over here, there was an outbreak of influenza, because of which schools got shut, and the drivers, who were mainly drivers of the school bus, since people are not commuting to school, there was no use of drivers, they did not have any job, they claimed for damages from the school owners, saying that they should be paid proper compensation. So, do you think they should be provided with compensation? And if the school authorities are not providing them with the wages or compensation, are they doing a breach of contract over here?
As we discussed before, that if the company or school have taken precautions regarding the influenza outbreak, then the driver can claim for the wages. But here the outbreak is consequential, they it can't be predicted by any person, so the drivers has no right to claim the wages uh, against the schools.
Okay, anyone else? Yeah, go ahead.
Yes, ma'am. Ma'am, no damages can be claimed because it was unforeseen and unpredictable. However, on the humanitarian grounds, the school can and the school may or should give compensation. But legally, they cannot demand compensation because it was unforeseeable.
Okay. Correct. So since they were contractual over here, they were contractual drivers, and the major role over here was they had to transport kids from their homes to the school. Since the schools were shut down, it was impossible for the authorities to pay them for the wages and compensation. Reason being that drivers come into, like, they come into role only when the schools are open. So now when the schools are shut and they don't know for how long the influenza will be, the Supreme Court of North Dakota discharged the school district from paying the bus drivers during the period that schools were shut due to the influenza epidemic. It is pertinent to note that the reasoning was based on the fact that the contract had become impossible to perform due to shutdown. So the major contract for which they had entered into was the service contract, was that the bus drivers are going to perform their duty of transporting kids from home to school, and school is in exchange is going to give them the wages. Now if that basic your duty of the contract is not being performed, and it is impossible to perform, your contract will come to an end, it will no longer be in existence. That's why the school authorities were not called for paying any compensation to the drivers. So with that, I think so you all have got a better understanding about the clause and when it is applicable, when it is not applicable. Now let us understand about the difference between your frustration of contract and breach of contract. Your contracts come to an end because of certain situations. One is your breach of contract. Breach of contract, in very simple terms, is when the parties fail to perform their duty, that is willingly, with an intention. When with an intention, if a party fails to perform the duty, for example, A and B entered into a contract for delivery of goods, and B, weather is good, everything is good, but B was not in a mood, just not in a mood to deliver the goods on that particular time. So he did not do it. So over here he is breaching the contract because he failed to deliver the goods at a prescribed time, at what time he was required to be delivered. So that will be considered as a breach of contract. What do we mean by frustration of contract? Frustration of contract happens when both the parties are at a situation which makes them totally impossible to perform their contractual duties. That is when your force majeure clause or act of God comes into play, because over here, even though parties want to perform their duties willingly, they are not able to do so. They are being stopped or prohibited by certain scenarios, their surroundings. That can be act of God or act of people. So you can read out the difference. The definition difference between frustration of contract and breach of contract is that a doctrine where a contract becomes impossible or radically different to perform due to unforeseen circumstances beyond the control of the parties is considered as a frustration of contract. Your breach of contract means a failure by one party to perform its obligation under a contract. Okay, now what can be the causes when these type of breach of contract or frustration of contract can be considered the situation? Your frustration of contract can be caused because of unforeseeable event, that is war, natural disaster, government intervention. And your breach of contract can be a voluntary act or omission by one party. So it can be like, as I said, that the other party willingly did not perform the duty, so that will be considered as breach of contract. Next is your effect on contract. What will happen in that situation if a frustration of contract will appear? Contract is terminated automatically. Whereas in breach of contract, the parties have right to claim for the damages from the breached party because he willingly breached the contract. He willingly did not perform his contractual duties. So over here, the parties are getting right to file for the damages. Whereas in your frustration of contract, the parties don't have the right to file for the damages because they could not have foreseen this situation. They could not have predicted this situation or taken any action against it. Next is your liability. Liability we already covered. Remedies. No specific remedies available. Parties may recover money paid or property transferred before the frustration event. Damages, specific performance injunctions, etc. So in breach of contract, you can claim for remedies such as injunction or specific performance of the contract, or you can claim for compensation or damages. Correct? By filing a suit against the breach party. Whereas in frustration of contract, you clearly don't have any remedies. However, there are certain points you have to consider into, such as like okay, the unforeseen event has happened, such as let's consider war. As a normal person, you will be aware that there's a war situation going on. That's why the other party is not able to perform their contractual obligations. Now, you have waited for a certain period for the war to put end. Correct? You waited, let's say, for a year for war to end, but you can see that war is not ending anywhere. That means your contract has terminated automatically. But what if that war ends, like it was just for a period of 3 months? What will be your duty? Once everything resumes, you will be expected at least to get in touch with the other party within a stipulated time if everything gets settled in. Okay, in that situation, you will be expected to take all the reasonable precautions and measures to get in touch with the other party and then re again decide the roles of each other whether to continue with the contract or not. All right, having got it clear so far. Okay. Okay, now tell me what will happen if there is no force majeure clause in your contract. So far, we have been discussing that parties will insert a force majeure clause and they will protect themselves from any kind of unforeseen event. They can also claim for the damages if there was no such act of God or anything. But what will happen if there is no force majeure clause in the contract? How the parties will be able to cover up their damages or say that protect themselves from the liability? Want to make a guess? Anyone? Okay, now let us understand this by way of Indian Contract Act. So there are two sections under Indian Contract Act. One is the section 32 that talks about our contingent contracts, and section 56 that talks about frustration of contract. So even if there are no such proper clauses which are there in your contract, because now things have got advanced, now people are taking proper precaution and entering the clauses. But if you go back to the old times and if you see that there was not much more awareness about these topics or these issues, so they used to enter into a very simple contract that mainly talked about their duties and what will be the ultimate situation, like how they're going to pay to each other, what will be the service they will be providing, and how the contract will be ending. But now we have got advanced and we have got aware. We have mentioned different clauses such as force major clauses in our contract. But what will happen if a case comes up where this clause was not mentioned at that time, and it is around 90s case, and the contract was still prevalent till date, but a force major situation happened, and that contract does not provide any clause with regard to the same. In that scenario, you are going to refer to the statutes, what the law says, what the law talks about. So majorly your two sections will come into play, section 32 and section 46. That is also dependent on the situation. Contingent contract, we all know what contingent contracts are, correct? Contingent contracts are the contracts that will happen only on happening of a certain situation. For example, A and B entered into a contract to let's say A entered into a contract with B, providing him a condition that he is going to pay 1 lakh rupees to B only when he marries C. Now, this is a contingent situation. It may happen or it may not happen. If it happens, like if B marries C, then only the contract will be properly coming into existence. Otherwise, the contract will be considered as void. If B marries C, then A will be liable to pay B with 1 lakh rupees. But if B fails to marry C, then A will not be held liable to pay 1 lakh rupees to B, because this contract was based on a situation that if this happens, then only he's going to get 1 lakh rupees. So, what if in this situation C died because of a natural calamity or something, making it impossible for like C dies because of certain event and making it impossible for B to marry C to get the 1 lakh rupee. The contract will come to an end. It will become a void contract. Whereas when we are talking about your section 56, section 56 talks about your frustration of contracts. It talks about the situation when your contractual obligations will come to an end or when your contract will be considered as terminated. Valid contracts that becomes impossible to perform due to unforeseen circumstances. Trigger, mainly your section 32 get triggered when occurrence or non-occurrence of any uncertain future event happen. Like I gave you in the example that if C dies because of certain reason, then it will be impossible for B to marry them, making it impossible for them to execute the contract. Section 56, it will mainly come into existence when particular act which the parties enter into becomes illegal or impossible. The word impossibility over here covers up our force major clause, because your act of God and act of people, that is mainly your war, strikes and riots, covers the act of people. Act of God will be your all the natural calamities, making it impossible for the parties of the contract to perform their contractual obligation. When we are talking about illegality, it mainly refers to the what if certain act at the time of entering into the contract, let's say weed. Before, at the time when you entered into contract, weed was considered as a legal object which can be easily sold in stores. Okay, now a certain law is passed by and now weed is considered as illegal and you cannot clearly sell or store the same with you. So that will make it illegal and parties can no longer be held responsible or liable to continue with their contractual obligations had they been entered into trading of weed, correct? Because now that is being considered as an illegal activity, so automatically your contract will come to an end and that will be considered as your frustration of contract. Clear so far? Okay. Now, when your section 32 becomes enforceable, your contract becomes enforceable only upon the happening of the uncertain event. If the event becomes impossible, the contract becomes void. Like in our situation of uh, B marrying C. If C dies, it will become impossible for B to marry C, making the contract void. But your section 56 says that contract becomes void due to impossibility or illegality arising after the contract was made. So once your contract was entered into, and if after that any unforeseen event or situation happens, or anything becomes illegal, that time your section 56 will come into the role. Your control of parties. In case of your contingent contracts, the parties have expressly agreed upon the contingency, means they are totally aware of the situation of the contract and when the contract will be considered as enforceable. Whereas in your section 56, the parties cannot predetermine or foresee the situation. They cannot held each other at fault of the either party, because they both were not aware of the situation that may arise in future. Now, when we are talking about remedies, in case of your contingent contract, there are no specific remedies mentioned. The contract is either enforced upon the happening of the event or becomes void. But in case of your section 56, the contract is terminated. Court may order restitution of benefits received under the contract. So it may happen, like I said, that if two parties were there in the contract, one was about to perform the duties and the other was obligated to pay for the fee, whatever services that the party has provided. So in that situation, what if the party has already provided you with all the services and you have received all the profit out of it? To make it simpler, let's consider A entered into a contract with B for the purpose of creation of a software. Okay, now that software was created by B. A was obligated to pay B, but B has already delivered him the contract, and A is residing in America and B is residing in Bangladesh. Okay, now in this situation, B has already performed his duty and is waiting for the payment, but he is not able to get in touch with A directly, or he's not able to communicate or do anything further with the contract. Let's say that he performed half of the software. Okay, he performed half of the software, he made it well and it is totally functioning, and A has already started generating profits out of it. But since B is not available and is in a situation that he has died, or let's say that because of the riots and strikes he has died, now the pending amount, do you think that A should be held liable to pay for the payment, like to pay for the services that he has received from B? I'll take it as yes. Reason being because B already delivered him half of the service. He has already got profits from that service and he is yet to pay for the payments. Now, it is the duty of A to wait for the situation to settle in, so that once the situation settles in, he is going to transfer the service fee to B. If not B, if B is not there, to his successors, whoever is there legally. Okay, so it is the duty of A, and in case anything happens, the successors of B are going to file a case against A, saying that he did a breach of contract. Because over here the force major clause will come into role, because force major clause is not overall you're simply saying that in case any natural calamity or any situation happens, this contract will come to an end. It is going to provide you with proper guidance, like what's the procedure in case these situations happen, how, what will be the time duration for how long the parties are going to wait, how long the parties are going to wait, or how long parties are going to pay each other for the same. Okay, so basic difference of your section 32 and 56 is clear. Can I move ahead? Okay, now how to draft your force major clause. Many of you have been practicing, or I have been noticing that people offer you different thousand templates of the contract, 100 templates of the contract, and you simply go for the same and copy it and create a contract. Don't do that. Because if you're copy pasting a contract or creating or finding a template and just editing the same, you are not creating a good contract. A good contract requires to be drafted from a scratch, because it requires your attention, what you are providing. Your client is paying you for the purpose to have a good binding contract that protects them, correct? So if you are simply copy pasting a clause, it may happen that you are not looking into the situations, or you're not considering all the points. Now, let us understand that what are the points you have to consider while drafting a force major clause. First thing is, who should bear the risk. So you can take a picture of this, that what are the questions you should consider while drafting a force major clause. First is your who should bear the risk. Now, in situation like I explained about A and B entering into a software contract, what if A had already invested in the creation of the software, and B is not able to perform his duty because of unforeseen event. Now, what will happen to the amount that A has already paid? What will happen to the same? So, in while entering into the contract, parties bear in mind that they have to bear a particular amount of risk, because that's impossible. Without risk, you are entering into any type of contract. Risk follows up with a contractual obligation. So over here, it should be predetermined whether, if parties don't want to bear up with the risk, what they do, they insure the product. So let's consider that if goods are being transported from one country to another, if they are being exported, in that situation they are usually insured, so that whatever the situation happens, they can at least claim the insurance amount, correct? Like in your situation of any situation, like in your situation of Titanic, there was it was not possible for them to predict that an iceberg is going to be there. That's why people in the Titanic were insured pre-handed before entering into the ship, so that their life is secured. And in case of situations like this, they are properly being compensated by the insurance company, because they paid the fee and they are eligible to receive the compensation. Next is your consequences. What will be the consequences if the parties are not able to perform their contractual obligations? What will happen then? So you have to consider the importance of the contract, importance of the work for which parties are entering into the contract. It will not only be that the parties are entering into contract for the purpose of sell or purchase of goods and service, or transportation of goods or service. It may happen that the parties have entered into contract for the purpose of construction of a building, or for any other purpose. So in that situation, what will happen if the construction is put on hold? Let's consider that parties had entered into a contract for the purpose of creating a dam. Now, uh, out of nowhere, suddenly flood happens. Okay, in that situation, it will be impossible for them to construct the dam or continue with the construction. It may happen that whatever they had constructed is no longer there because of the flood situation. Now, what will happen in that scenario? So you have to consider all the consequences. Who is going to bear the loss? Who is going to pay up for the damages? What will be the consequences in that scenario? Continued payment. So this clause will mainly come into role in your employment contracts, because let's consider that, again, consider your COVID situation. Many people were not able to work because of the COVID, because they were not able to get out of the house. What if that situation would have been continued for a period of 2 years and people are no longer being able to work? Okay, in that situation, do you think your employer should be held liable to pay you continuously irrespective of the circumstances? He cannot do so, because there will be a certain limit till which he can pay you for the pay your salary or pay your wages to keep your house running. After a certain time, he may get he may does not have enough money to pay for your wages or salary. In that situation, he is going to stop the payments. So under that, your force major clause will also provide proper duration for how long you are being secured by the compensation in situations like calamities or act of people or war. Okay, next is your termination. Now, termination, when we are talking about, it does not mean that a certain situation happened, a calamity happened, and your contract come into an end. Because whatever the situation is, with time it is going to come to an end one day or the other. So you have to properly prescribe the duration of days after which your contract will come into an end. So you can mention it in this way, that parties are obligated to inform the other party within a period of 7 days in case any uh, uncontrollable event is happening. Okay, after the happening of that event, they have to inform the other party within a period of 7 days. And if that situation prolonged for a period of 90 days, this contract will eventually considered to be terminated. So that's how you're going to label up your force majeure clause when it comes to your termination. Meaning, now your force majeure meaning can be considered different for different people. As we discussed initially about vis major, some people may just cover your vis major clause, saying that this contract will be terminated in case of any vis major or act of god happens. They may not cover the definition of act of people. So it is important that you define about what do you mean by the definition of force majeure. Similarly, with the events, you have to clearly define the events in your force majeure clause which you will be considering as an unforeseeable or uncontrollable event. So you can divide it into different parts, such as your act of god. Like you can describe the events, earthquake, tsunami, cyclones, tornado, all will be considered as your act of god. And in act of people, or you can define over there that rights will be considered as an act where parties are not able to do their contractual obligations. So this way you have to define the events as well in your force majeure clause. It's just not about that you simply say that in case of act of god, this contract will be considered as terminated. It cannot be in simple line. So you may come across different type of clauses in your this thing, different type of clauses when you are reading a contract or going through a contract or reviewing a contract. Okay, so some clauses you may come across are your this type, this short, that take a minute and go through the same. Okay, these are the samples of your clauses of a force major clause, which are mainly given in a where you think that it is not required to give such detailed description of force major clause. So in that scenario, you can simply cover up the force majeure in these simple wordings and in a short paragraph only. So take a minute and go through the clauses. Okay, so now I'll read it for you. The party affected by force majeure shall not assume any liability under this agreement, however, subject to the party affected by force majeure having taken its reasonable and practicable efforts to perform this agreement. The party claiming for exemption of the liabilities may only be exempted from performing such liability as within limitation of the part performance delayed or prevented by force majeure. Once causes for such exemption of liabilities are rectified and remedied, both parties agree to resume performance of this agreement with their best efforts. So by reading this clause, you can understand that they have made it like clearly evident that parties shall not be held liable under this agreement in case they get affected because of a force majeure. That is an unavoidable situation. However, subject to the party affected by the force majeure having taken its reasonable and practicable efforts. Means even in the situation like force majeure, parties are taking all their practicable and reasonable precautions to prevent the damages which the other party has to bear. The party claiming for exemption of the liabilities may only be exempted from performing such liability as within limitation of the other party performance delayed or prevented by force majeure. So even in situation like force majeure, you will be getting, like you will be not held liable only when, or you'll be held exempted from the performance of such duties only when you have taken proper precautions from your end. And once your situation is resumed, once you are in a normal situation, the clause also provides that you will be held liable to provide or remedy or rectify whatever damages has been happened. both parties agree to resume performance of this agreement with their best efforts. So that means that after the force major event, both parties will try from their ends to continue with their contractual relationship. Okay, so that's how a force major clause is drafted. So it can be in form of your like you can label up your paragraph, like in this situation it is 10.2, paragraph 10.2. Then you have mentioned or talked about your force major, or you can label your clause with a force major, and then you can define about uh, whatever the situation is or the rights of the parties are, as you can see in your example 2. Now we are talking about that we have to frame up about, we have to define all the events and properly define the meaning of the force major. It is impossible to clearly think of all the unforeseeable events or imagine them or write them down, because there are multiple areas or events that can happen which you cannot even think of. Like COVID-19 was one of the situation you could not have predicted at all that it is going to happen. Correct. So what will happen in that situation if you have failed to mention any of the particular event in your clause? Like alien attack, it may happen. Okay, in future anything is possible right now, so it may happen. Let's consider an alien attack is possible, and you could not have possibly predicted that it is going to happen. What will you do in that situation? So in order to keep your contract a wide range to cover from all the directions, you will focus on the language of the clause. That is your catch all phrase. These are the wordings which are mainly used to broaden the definition of your force major clause. So you can include words like including but not limited to, or any cause event outside the reasonable control of the parties. These are your catch all phrases which you can enter into your force major clause to cover all type of events which you have not like clearly defined in the definition of force major events. Got it? Okay. Now give me a minute so that I can quickly take you through a properly drafted, well defined force major clause. It will be a longer one, so give me a minute. Okay, let me know if my screen is visible to you all. Can you see a different screen right now? Oh, what? Just unmute and answer because I'm not able to see right now. Okay. Yes. No. Please answer anyone.
Yes,
Yes.
ma'am.
Okay, thank you. So this is your well-crafted force major clause of a MSA. So MSAs are mostly your lengthy documents which parties enter into for the purpose of exchange of service for a period of 5 years, 10 years, or 15 years. So in that type of situations, when you are entering into such longer durations of contract, it is totally impossible for parties to predict the future. Like what will be the situation after 5 years? Okay, so they provide a well-defined force major clauses which covers everything. So if you can notice over here, they have defined the definition of the force major clause. So this is the name of the party. Kindly don't look into it. It is a very longer name. So let's consider the PDMA, as the case may be, shall be entitled to suspend or excuse performance of its respective obligations under this agreement to the extent that such performance is impeded by an event of force majeure. So they are simply talking about what do they understand by the word force majeure, and what will happen that they shall be not they shall be entitled to suspend, like that is terminate the contract or excuse the performance of its respective obligation. Means they shall not be expected to continue with the performance in case of force majeure situation. Now they have clearly defined the force major events. You can see that they have subdivided it into non-political events. Over here, they have covered things like act of God, including earthquake, flood, inundation, landslide, exceptionally adverse weather conditions, storm, tempest, hurricane, etc., etc. You can also notice that they have mentioned about radioactive contamination, ionizing radiation, etc. Then they have also talked about your strikes, lockouts, boycotts, labor disruptions. So these type of things can also be mentioned in case of parties who are entering into contract for like factories contract, when they are entering into a manufacturing contract, correct? So parties may be held liable to produce something, and for that production they might be in need of labors, correct? So what they will not be able to get the laborers work because of a strike or lockout situation. So those type of situations are also covered under this. Now they have also talked about your other events, that is your act of war, hostilities, invasion, armed conflict, etc. So all these type of events have been clearly defined over here. And also they have provided a general meaning of the events. You can notice on the first and second third lines they have said is beyond the reasonable control of the affected party. Such party could not have prevented or reasonably overcome with the exercise of reasonable skill and care, does not result from the negligence of such party or the failure of such party to perform its obligation under this agreement. Okay, so over here they have also provided a general meaning. Along with that, they have also provided you a detailed meaning of the events. What are the events they are including? Now, if you can notice, they have provided you with a notification procedure for force major. Like what are the specific guidelines they have to follow in case of force major situation. Read down the paragraph A. It says that subclause A says the affected party shall notify the other party of a force major event within 7 days of occurrence of such event. If the other party disputes the claim for relief under force major, it shall give the claiming party written notice of such dispute within 30 days of such notice. Such dispute shall be dealt with in accordance with the dispute resolution mechanism in accordance with clause. So with that you can understand that they have to give a 7 day, they will be getting 7 days to provide notice to the other party if they have been stuck in some kind of force major situation, or if any party wants to claim for the damages or for reliefs, they have to notify the other party by giving them a 30 days notice. Next is upon cessation of the situation which led to the party claiming force major, the claiming party shall within 7 days hereof notify the other party in writing of the cessation of, and the parties shall as soon as practicable thereafter continue performance of all obligations under this agreement. So once the situation is properly resolved, they are no longer in the force major situation. Again, they are contractually binded to notify the other party within a period of 7 days that now they are able to continue with their performance, their contractual obligations. Now you can also notice that they have provided with allocation of costs arising out of force major, like who will be the parties bearing up with the costs. There can be situations that parties have already entered into contract but are yet to perform their duties, because it may happen that you have entered into a contract, let's say on 20th July, but 20th July 2024, but you will be starting with your service from another date. Let's consider September 1st. Okay, you are yet to perform with your services, you are yet to join the office, let's consider. So you haven't provided any services so far, you have already entered into contract, executed the contract. So what will happen in that scenario? In that scenario, they have mentioned that upon the occurrence of any force major event prior to the effective date, the party shall bear their respective costs and no party shall be required to pay to the other party any costs thereof. So even though you had entered into a contract, but since you were yet to properly execute, like yet to properly put that contract into effective use, it was not effective, because effective date is different and your execution date is different. In very brief, your execution date in a contract is considered as a date on which you signed the contract. Okay, and your effective date will be considered as a date from when your contract will come into existence, like from when you will be actually start functioning or using that contract. So that will be considered as your effective date. Now, even though you have entered the contract, you will still not be held liable to pay for the damages in case of any force major situation happens, because you were yet to join the company, you were yet to provide the service. Next is, upon occurrence of a force major event after the effective date, the costs incurred and attributable to such event and directly relating to the project, force major costs shall be allocated and paid as follows. So, in case of situations where the parties were already into a contract and they were performing their duties, they have further provided what will how they are going to share the losses, how they are going to distribute the damages. Okay, and with that they have provided proper definition of, like, upon occurrence of a non-political event, the parties shall bear their respective force major costs, and neither party shall be required to pay to the other party any costs thereof. So whatever investment they have done, they will be bearing up with the same. No one is going to file a case against each other in case of a force major situation like this. So that's how you are going to predefine everything in your force major clause. And also, last will be your consultation and duty to mitigate. This clause majorly talks about, like, it will be the responsibility or duty of the parties to try to mitigate the losses of the damages, to take all the necessary precautions they can take from their end to prevent the damages. Okay, so with that you cover up the overall force major clause, which went up for 1.5 page. So that's elaborative and well defined. Force major clauses are done in your major contracts. In simple contracts, you can simply define it by a way of, like, simple one or two paragraphs. That's all. You are not required to mention in detail clauses. So with that, we have covered the overall force major event and definition. And yeah, that's all. Any questions? Any doubts? Any questions? You got the concept clear, or you are totally unaware of the concepts? Okay, all right. So now coming on to it, yes, we'll be sending you this PPT in the group. Along with that, you'll be receiving a recording of this workshop, which you can consider, like, which you can go through. Along with that, we'll be also providing you with the certificate of the this workshop. So we'll be sharing a feedback form in the group. Make sure that you fill that up with your correct names to receive your certificate. Now, apart from this, if you are interested in learning more about contracts or found this workshop as insightful, you can go for the courses such as contract drafting course, and along with that, international contract drafting course. These two are the courses which majorly explain you about how a contract is drafted, what are the major business agreements companies enter into, like such as a master service agreement, NDA. When I am talking about international contract, that will brief you out about how big multinational companies enter into contracts with international borders, what are the points they look into, and other things. Okay, so you can consider both the courses, and they both are live courses. You will be understanding overall step by step guide on how to draft these contracts. The reason I am suggesting that these will help you in getting job in corporate. Also, if you don't get a job, okay, let's consider, because we at LeDroit make sure that you are properly having skills. You don't have to look for job should come to you. You should be having the skills. So you should be prepared. Even though, let's consider that you are not getting a job, you should be able enough to earn on your own. You don't have to be desperate to find a job. You should be having enough skills to earn on your own. So with that, just learn the contracts. You will be able to have the skills to get clients from outside to work as a freelancer. If you need any help with the freelancing as well, I'll highly recommend you to go for the course on freelancing, because in freelancing course you will have proper understanding of how to get the clients. It is one thing that you know the skills, it is another thing that you know how to get the clients. So in that course we will train you step by step with personal guidance on how to get clients, how to negotiate with clients, what are the skills they demand from you. how to create your profile on different freelancing platforms like Upwork, Fiverr, and other things. So even after your course is over, we will be there to guide you properly. In You can always stay in touch with us if you need any kind of guidance. So yeah, with that, I put an end to the today's workshop. I hope you all enjoyed. Thank you so much for your time. We'll be updating the rest in the group, so don't leave the group. We will be sharing the feedback form over there. Make sure that you fill that up, and your certificates will be issued within a week's time. Okay, once it is shared, we will notify in the group. Yes, anyone is raising their hand? Just one.
Yeah, yes, ma'am. I just had one question.
Mm-hmm.
Like, if we are going through any contract and if we are not able to kind of understand any clause, so like, so some of my friends, like, they were just telling me, like, if you just cut, copy, paste it into Google, you're gonna get to know the elaborate definition. So is that kind of true? Like, it might be a lame kind of a question, but I'm just asking out of curiosity.
Okay. All right. So, that question actually is a concern of many lawyers these days because of growing, you know, thing about AI. So now many people do what they do is they even get the clauses drafted by the AI tool, Chat GPT, and other stuff. See, technology will advance. You cannot stop it. But what you can do is stay updated with the technology, and you know how to use it. You will notice that even though they have provided you with the clause or meaning of the contract, they will provide what they have understood after doing the Google search, whatever is there on the internet. But when it comes to human understanding or application of emotions or understanding of your intelligence, you will eventually decide that whether this thing is correct or not. So you may Google it, you may seek that understand the clause by Googling it or understanding, but eventually, if you are still not able to understand or if it is of paramount importance, you should get a proper human consultant, that is a lawyer. You should consult it with your seniors and get proper guidance on the same. Some things, of course, your technology can help you out with it, like you can do Google search and understand. But for major clauses such as force major, it is very much, I'll suggest that seek a senior to help you out with the understanding of the definitions and things.
Yeah, yes, ma'am. Thank you.
Okay, all right. So yeah, with that we have ended the workshop. Thank you very much. Have a very nice evening. Thank you.